When we looked at the law relating to end-of-life care, we considered the extent to which that should be driven by parliamentary decision and democracy, or the extent to which it was a matter of human rights that were properly the jurisdiction of the courts. And the case in Nicklington particularly is really important in terms of understanding where the law's got to in those respects. But we also explored the extent to which it was important to get legal certainty, even at the extent of perhaps doing the right thing. So we looked at the decision of the House of Lords in Purdy, which held that the rule of law required far greater certainty of when prosecutions might happen for what you might think was very obviously an offence. There was no real doubt whether or not the actions that Debbie Purdy wanted her partner to take would be beyond the scope of the law. They clearly would have been unlawful under the terms of the Suicide Act. But the leniency that the DPP is thought to have shown by declining to prosecute in some circumstances was held by the House of Lords in Purdy to mean that there was insufficient certainty to meet the requirements of the rule of law. But you might wonder whether or not they would have said that if the rules had been pointing in a more liberal direction. And was this really a formal question about the degree of certainty that the rule of law required, or was it judges feeling that the substance of the law was unattractive and that they wanted it changed? And that raises a serious question about the extent to which unelected judges should determine these things in a liberal democracy. But the question about certainty goes much further. When you look at the withdrawal of treatment cases, including Aintree and James, then you see a question about whether or not it's a matter for clinical judgment and the court should not interfere with it, which treatments are appropriate to offer. And in Aintree and James, they reinforced the position that the Court of Appeal reached in the Burke against General Medical Council decision, which held that it wasn't for the law to force doctors to give treatments that they thought were clinically inappropriate. So it seems to be that a degree of judgment and lack of certainty is acceptable to the judges, particularly when you remember the Bolam test, which allows for the fact there might be more than one school of thought that dominates a clinical decision. So as long as we accept clinical judgment and as long as we use open tests such as the best interests of patients, then the law is allowing for some degree of flexibility and allowing it to be tailored to the particular circumstances of the clinical situation and the patient's needs. And you need to decide whether or not you think that is a better approach given the variety of clinical circumstances, or whether you'd like to see clearly predictable rules, but recognising that the more predictable they are, the more it's likely that in some circumstances they will lead to lead to outcomes that you don't like. So we may be trading off a degree of legalism and certainty, which gives us perhaps in most circumstances the right answer, but sometimes ones that we think are unattractive, or whether we delegate the decision making to others such as doctors, in which case we trade off a degree of oversight and regulation, but we can be reasonably confident that greater flexibility becomes possible. So in a sense, that's a question of what is the limitation of law and how should it compare to clinical issues.